Hi all, welcome back to another important weekly issue of the Polity and Governance topics that for the week gone by, that's from February 19th to February 26th. So let's take a quick review of what happened with regard to the important topics for Polity and Governance, which is very important from your GS paper 2 mains perspective and also the preliminary point of view, and also for you to keep track of the news if you have missed out at some point of time, you're working, you're also preparing for other levels of studies, etc. So this is going to be really helpful for you. So the first important thing was the Sansad Ratna awards now were given to the MPs, and so these awards are only given to the members of the parliament, that is from the Lok Sabha and the Rajya Sabha. Now they were instituted in 2010 and are based on the teachings of the former President of India, APJ Abdul Kalam, and they were first given in 2010 in Chennai. Now they seek to recognize the performance of the members of parliament on the basis of their work in the apex legislative body, that's the parliament. The Sansad Ratna Awards, as I told you, is based on the teachings of former President APJ Abdul Kalam, and they honor the top performing members of the parliament. So recently 13 MPs have got the Sansad Ratna Awards. So how do the MPs get chosen for this award? Now the Sansad Ratna Awards, there is a press release that mentions that it's jury members consisting of the eminent parliamentarians, some members of civil society. So now the jury member was chaired by the Ministry of State Parliamentary Affairs and co-chaired by the former Chief Election Commission of India. So they call for nominations and then they check the performance of the members of parliament in the sessions. So the performance of the MPs beginning from the 17th Lok Sabha have been checked till the winter session of 2022, and 13 names have been come out for the Sansad Ratna Awards for parliamentarians. The next important issue is that now only Parliament, the Supreme Court says that only Parliament can amend a law to provide for uniform marriage age for women. So there is a debate already in the country that there needs to be a uniform marriageable age for women on par with men, which is 21 years. So currently, the women have the marriageable age of 18, so they want to increase it on par with men to 21 years because of certain social issues like delaying marriage, more empowerment for women, etc. There is also a bill brought for about this in the parliament, but it's pending in the parliamentary standing committee and it hasn't been passed. Now there was a PIL submitted by one advocate named as Ashwini Upadhyay, who called for the Supreme Court to direct the government to increase the marriageable age of women on par with men. And the PIL urged the court to strike down the minimum marriageable age for women, which is now at 18 years, and to bring them on par with men. The bench said that the matter is of the parliament to decide, and they cannot issue a writ under Article 32 of mandamus to the parliament to do so because it's a policy issue, and there's already a bill pending in the parliamentary standing committee. So this issue falls into the domain of the parliament, and the Supreme Court asked the advocate to go to the related ministry, that is the Ministry of the Women and Child Development. So what actually did the Supreme Court said? Now the Supreme Court said that it does not come under the jurisdiction of the judiciary to actually direct the government to do something like this because it's a policy issue, and that falls into the domain of executive and legislature. And it declined to entertain the petition, leaving it open to the petitioner to actually pursue such remedies like available in the existing law. The petitioner argued that the distinction between the men and women regarding to the marriageable age was arbitrary, and it violated various articles of the Constitution like 14, 15, 19 and right to life under Article 21, and sought that the marriageable age of women should be brought on par with men. The court, however, clarified that it cannot issue a writ of mandamus to the parliament to legislate, and asked the advocate to go to the related ministry, that is the Ministry of Women and Child Development. So the centre is already in the process of bringing up a bill, and there was a large-scale debate last year around this. So the bill is called as a Prohibition of Child Marriage Act, Amendment Bill 2021, and let me tell you, it's pending in the Parliamentary Standing Committee and it hasn't been passed. So there is still time, but yes, there is a proposal already pending in the Parliament, but no step as such to pass the bill has been taken. So the next most important issue is that the Vice President now, Jagdeep Dhankar, has taken note of the disorderly conduct of MPs in the Rajya Sabha and asked the parliamentary panel of privileges, that is the Committee on Privileges, to probe the issue. So according to the Rajya Sabha bulletin, 9 MPs from the Congress and 3 from the Aam Aadmi Party were accused of disorderly conduct in the House. So though the MPs have certain privileges to help them to function in a very efficient and fearless manner, but there is certain boundaries that they need to observe, and there is a code of conduct that they need to adhere to with regard to each house. Now the Rajya Sabha chairman, that is even the Vice President of India, Jagdeep Dhankar, said that the Parliamentary Committee on Privileges to investigate the alleged breach of privilege by the 12 members of the opposition. They were repeatedly entering the well of the House, shouting slogans and obstructing proceedings, and the chairman of the Rajya Sabha, that is Jagdeep Dhankar, had to constantly adjourn the House. He said that this is the display of violation of rules and etiquettes in the Rajya Sabha by repeatedly entering the well of the House, shouting slogans and persistently and willfully obstructing the position of the council, compelling the chair to actually adjourn the House, which means a waste of business time. The Rajya Sabha now saw repeated adjournments due to the protest by the MPs, and this led to a lot of waste of time during the first leg of the budget session of the Parliament. Now under rule number 203 of the Rules of Procedure and Code of Conduct of Business in the Rajya Sabha. So let me tell you, there is a Code of Conduct of Business and also Rules of Procedure for each house. So under 203 of the Rajya Sabha rules, the Committee of Privileges can examine, investigate and report the violation of the privileges or a breach of privilege in the House. This is an announced mechanism to check the issue of code of conduct of the members. Now each house of the Parliament has its committee, and the members of the House individually enjoy certain rights, privileges and immunities, but if there is a breach of privilege, then these issues are taken up by the Parliamentary Committee of Privileges, that is to safeguard the freedom, authority and dignity of the Parliament. So each house has its own Committee of Privileges, which consists of the members of that house, and the chairman of the member is selected by the chairman of the Rajya Sabha or the Speaker of the Lok Sabha, and it determines the reference with the facts with the breach of privilege and also makes suitable recommendations in the report regarding the members and also the behavior. The committee states the procedures then to be followed by each house, whether it is Rajya Sabha or Lok Sabha, what it should do with regard to breach of privilege. So this is a breach of privilege. It's very important because we already have in GS paper 2, that's Parliament, its functions, procedures, etc. The most important next issue is children have the right to protect their genetic data, and this was said by the Supreme Court. So once again, protecting the right to privacy, but last time it was in the Puttaswamy case, it was regarding to adults, but this time it's protecting the right to privacy regarding the genetic data of children, especially whose parents are in the process of a divorce. So the Supreme Court upheld the right to privacy of children and said that children have the right not to have their legitimacy questioned frivolously, that is just for the sake of it, or not having purpose to do it before the court of law. So the court said that the child has the right to protect their legitimacy and should not be questioned for no reason unless there is a real need for it before the court of law. The court said that this is an essential attribute of right to privacy, and this was said in the origin of a divorce proceeding in which the father actually filed a petition regarding he wanted to claim to see his paternity with regard to a second child from his wife, and this was what the Supreme Court said. So he wanted to take a DNA test of the second child to ascertain the paternity regarding the second child, as the case was related to divorce. Supreme Court said that the children have the right not to have the legitimacy questioned in any court of law because they right to privacy, and it said that this is an essential attribute to right to privacy, which comes under Article 21 of the Constitution. Courts therefore are required to acknowledge that children are not regarded like material objects and subjected to DNA testing or forensic testing, particularly if they are not parties to a divorce proceedings, and it is imperative that the children do not become a focal point in the battle between the husband and the wife. So this was said by the Supreme Court. Supreme Court also said that the protection of the right to privacy is an important facet under the Convention on the Protection of Rights of Child, and upheld this and said that this cannot be entertained. So once again, as a protector of the fundamental rights, especially this time with regard to right to privacy, last time we already had the Supreme Court upholding the right to privacy of individual under Article 21, and this time it's regarding the children, especially when there are cases of divorce. The next most important issue is about the central deputation. So we had a lot of issues and news regarding the states, especially with regard to West Bengal and Tamil Nadu, regarding deputing the All India services, that is the IAS, IPS and the IFS officers, to the central secretariat for a brief period of time. So this is according to the All India rules. So in a letter now to the states government, the Union Ministry of Home said that the state governments are withdrawing the names of selected officers and also asked the states to nominate an adequate number of IPS officers for central deputation. The tussle between the union government and the state government with regard to the central deputation has been going on from quite some time, and this can be seen especially with regard to the states who are not having the similar political party that is ruling the center, that is the non-BJP ruled states. Now in 2020, the Union Home Minister had ordered the immediate transfer of 3 IPS officers to Delhi on central deputation after the convoy of the chief of BJP, JP Nadda, was attacked, but this did not happen, and then there was a tussle between the center and Bengal. So the Bengal government went on to extend the tenure of the officers who were selected for central deputation. Now this has also taken a turn of a federal issue, the state saying that the center is twisting their arm by enforcing the rules, and even if they do not like, by forcing them to send the officers there on central deputation. So about central deputation, in the normal practice, the center asks every year for an offer list of the officers of the All India services willing to go on a central deputation, and after it selects the officers from that list, the IS cadre rule says that the officer with the concurrence of the state government and the central government can be deputed to the central government for a specified period of time, and in case of any disagreement, the matter shall be decided by the central government and the state government, or the state government shall give effect to the decision of the central government. Now there was a PIL in the Supreme Court recently asking that the rule of All India services, where the center says that the officers can be taken, should be actually strike down, because the rules because the states have to bear the brunt of arbitrary actions taken by the center, and the rules also make it very difficult for the center to enforce its will on the state, which then refuses to back down. So can the center then take an action against the officer who is not willing to actually go on deputation, or if the state prevents the officer? Now the center cannot take any action against civil service officials who are posted under the state government unless the state government also agrees. So Rule 7 of the All India Services says, that is of 1969, says that the states, it is when the officer is functioning in the state government, and if the officer is serving in connection with the state government, for any action to be taken against the All India Service officer, both the center and the state need to agree with it. And regarding the central deputation, definitely the states are supporting the officers. They want them to stay with them and are not sending a sufficient number of All India Services officers for central deputation, which is then facing a similar problem. So this is not only regarding the shortage of officers who have experienced from the state level going to enrich their work in the central level, but also it's taken a federal feature with regarding to violation of federal rights and center enforcing its actions on the state. So the next most important issue is that I've already spoken in my last video, is Supreme Court on the paid menstrual leave for women. Now again, once again, the Supreme Court has affirmed that it cannot issue a writ under Article 32 to the state, to the Parliament to do so, because it is a policy function of the Parliament, and it cannot venture into those duties of the Parliament. So the Supreme Court rightly said that it cannot issue a writ of mandamus asking the Parliament to bring out a policy to ensure paid menstrual leave to the women, when a PIL was submitted to the Supreme Court immediately after Spain became the first European country to grant paid menstrual leave to women. Now paid menstrual leave is nothing but leave given to the women which are paid actually, because during the menstrual cycle women face many physiological problems like cramps, pains, etc. Their BP level goes down, so low sugar levels, etc. This leads to their health issues, and for them to take sufficient rest, there is a section of the society saying that they should be given paid leave for this regard. But then there is an opposite argument also saying that if women demand paid menstrual leave, then there will be many companies who will not be willing to employ as much as women as they are in the workforce, and this will be a drawback for women empowerment as well. Let me tell you that Bihar and Kerala are the two states in the country who are allowing paid menstrual leave for women in the country. So the petition was filed on the basis of Maternity Benefits Act 1961, which protects the rights of women with regard to motherhood, and the petitioner said that menstrual cycle is the first stage to maternity, and therefore the paid menstrual leave should be protected under this act. And so it wanted the Supreme Court to order the centre and the states to come out with a policy as soon as possible to provide women who are working in educational institutions, students, and also in other organizations, government as well as private, to allow a paid menstrual leave. So the matter is not been there was no order issued. The Supreme Court denied from entertaining the PIL actually. The most important next news is about the allocation of election symbol and the party name now to the Maharashtra faction of Eknath Shinde, that is the Shiv Sena faction of Eknath Shinde, which broke away from the main Uddhav Thackeray Shiv Sena political party. So some now, so the Election Commission of India recently allotted the party symbol, that is the bow and arrow, and the party name to the Eknath Shinde faction, who broke away from the main political party, that is the Uddhav Thackeray faction, in last year in the month of May, after there was a group of MPs who started to support him, and then they went on to form the government. Now some experts expressed doubt about the method that the Election Commission has used to allocate the coveted party symbol of bow and arrow and also the main party name of Shiv Sena to the Eknath Shinde faction, who broke away from the Uddhav Thackeray party. It only means now that the Eknath Shinde faction of Shiv Sena will reign now, as they have the party name and the symbol. The Election Commission decided to give Shiv Sena the symbol instead of the Uddhav Thackeray, because it did so based on certain tests and also certain criteria which it followed after the Supreme Court judgment of 1972 in the Sadiq Ali case laid down certain criteria. So to come to this decision, the Commission considered which of the two factions actually enjoyed greater support among the members in the state legislature and the parliament as well. And it adopted this method after other tests has also been taken, but that proved inconclusive. However, constitutional experts are of the view they are divided whether the procedure actually followed by the Election Commission was sound. So the Shiv Sena had split in June 2022 after Shinde and his supporters fled to Surat. They caused the fall of the Maharashtra government, which was called as the Maha Vikas Angadi coalition, comprising of the Shiv Sena, the National Congress Party and the Congress. The Sena's Uddhav Thackeray was the chief minister at that time. Now both the factions later on went on to claim the party symbol and also the name, and they approached the Election Commission, and recently it was the Election Commission who decided under the Symbols Order of 1968 to award the party symbol and the name to the Shiv Sena faction. Now experts are divided, as I told you, the constitutional experts are divided. They say that the Chief Commissioner, as actually the Election Commission of India, has not taken all the criteria into consideration and only went with that test which was considered to be fit and which was apt for the situation. So it did not do all the tests in completion. So what is the political implication now of giving the symbol and the name to the Eknath Shinde faction actually? Now the Election Commission's decision carries a lot of political implications, because now ahead there are two assembly by-elections in Maharashtra and also the civic body elections in the state. Let me tell you that the Shiv Sena have a very, very big following in the Maharashtra, and that's the main political party. So definitely this time is going to be Eknath Shinde's faction that will have a larger weightage because of the party symbol and the name. The next most important is that Congress was calling out at the plenary session for a caste census. Now why? Not only Congress political party, but there have been many states who are already carrying out a caste census. There have been a demand from various sections of the society also, and especially from the OBCs, that there should be a caste census along with the recent census that is being conducted for 2021. So census 2021 hasn't been conducted because of the pandemic situation, and let me tell you, this is the first digital census to be conducted conducted. So the very first census in India was conducted during the British period of 1872. Now the caste census is nothing but a tabulation or the enumeration of the caste-wise data of Indian population in the census along with other data. So the demand for consensus is a very long one, and this demand is now rising, and they want the data to be added in the census 2021. So from 1951 to 2011, every census in India published the population of two communities, that is the scheduled castes and the scheduled tribes, comprising the Dalits and the Adivasis, along with the entire gamut of information regarding the religions, languages, socioeconomic status, etc. It, however, never published the data regarding the OBCs, which according to the Mandal Commission and which is now followed, they constitute 52% of the country's population. So all the castes other than the scheduled caste, scheduled tribe are counted under the general category, and that is why now there is a demand for a caste census, especially aiming to count the castes that come under the OBCs. Now the first census in India began in 1872 and the periodic count officially started in 1881. Since then, the data on the caste has always been on the paper until only 1931. The caste census was excluded in 1941 because of administrative and financial issues, because England was involved in the World War II at that time. So the count of the OBCs officially is actually available only until 1931, and after that we do not have an official count of the castes that comprise the OBC. Presently we follow the percentage that they constitute 52% of the population. Now that is why there is a clamour for a caste census, and many political parties, many states, recently even the Samajwadi Party, it's become a very big issue that they want a caste census. So have we actually counted the caste previously other than the data till 1931? Yes. Previously, before the BJP political party coming to power, the Congress government had counted the caste census in something called as the socio-economic caste census, which was conducted in 2011. But the data with regard to the caste have not been made public. It is with the Ministry of Social Justice and Empowerment. And now there is a demand to make this data public too. So why a caste census? We know what is the demand, but how will it help? Definitely it will help to measure the economic and social well-being of the castes that come under the OBC, and also targeted beneficiaries. So that's the reason, to ensure that the reservation is going to the beneficiaries who mostly need it. And the most important one now is on the media. So media has been in news because of the reporting of the Adani Hindenburg reporting issue with regard to the Adani, the manipulation of stocks and also the accounts. So a plea went out to the Supreme Court once again to issue a gag that is on the media on the Adani reporting. So the Supreme Court denied straightly and said that they are not going to issue any injunction ever regarding the gag on the media, and told the advocate to file a plea contending that the media, but the plea was filed that the media was actually sensationalizing and blowing the issue out of bounds. So the Supreme Court rejected the plea, stopping the media from reporting on the Adani issue till the court takes a decision regarding the petitions that are pending before it. So there are a series of petitions pending before the Supreme Court regarding the Adani issue. So the Supreme Court termed the PIL, which asked to put a stop on the media reporting, as unreasonable, and the top court said that the interests of Indian investors need to be protected against the market volatility, against the backdrop of what's happening with regard to the Adani Group stock rout, and asked the centre instead to consider setting up a panel as soon as possible. The advocate, on the other hand, said that without verified evidence, it is dangerously exploding the issue on the media. Various media houses are doing so, and this cannot be allowed to be released. The media cannot do such things without any verified evidence, which is only scaring the investors and also creating a panic-like situation. He claimed that the media hype has crashed the Indian stock market to like more than 50%, and therefore said that it is creating a panic-like situation among the investors investors who are going on a selling spree actually in the stocks and are also suffering financial losses. But the Supreme Court restrained to put a stop on the media reporting, saying that it protects the consumer rights. So once again, Supreme Court very clearly saying that it favors the consumer rights more than actually stopping the media reporting, because the consumers need to know what's actually happening. And the other next important topic is that if you're a bird lover, and if you really like to watch birds and you're a wildlife enthusiast, then you have the Great Backyard Bird Count 2023. So recently, the Great Backyard Bird Count, which is the Indian implementation of the global Great Backyard Bird Count, which runs for 4 days every February, is being conducted in India, and Indian birders have participated in this backyard bird count since the event was launched in 2013. So India has a wide variety of wildlife, not only wildlife but also bird species, flora and fauna, and it is one of the mega biodiversity hotspots of the world as well. So in the 2022 edition of the Backyard Bird Count has engaged almost 3,000 more birders, who uploaded almost 40,000 checklists and recorded 1,000 species of birds in India. So this is coordinated by an organization called as the Bird Count India Collective, which is a number of groups and organizations that come together who are interested in birds, nature and conservation during this bird count. Now it has been reported that West Bengal has the highest number of bird species, followed by Uttarakhand and Arunachal Pradesh. Now bird watchers across 35 states and union territories uploaded more than 46,000 bird lists, making India take the second spot after United States of America in this regard. So India has a large number of wetlands also, and we have a large number of birds coming to feed on their food, especially during the migration season. So India is a land of birds and also wetlands. And the next most important issue is with regard to culture. So you have the Sangeet Natak Academy Awards that are going to be given by the President. So let me tell you that culture is a very important part of the Indian society, and we have directive principles of state policy and also your fundamental duties calling to protect culture. So India's unique performing arts have kept our culture alive, and we have an organization which participates in performing arts like music, dance, drama, which is called as the Sangeet Natak Academy. And our arts and artists have actually carried forward this rich cultural heritage. Unity in diversity is the biggest feature of our cultural tradition in India. President of India presented the Sangeet Natak Academy Fellowship and Academy Awards. Now Sangeet Natak Academy is also called as the National School of Dance, Music and Drama, and it is located in New Delhi, and it is involved in protection and promotion of several art forms in various parts of the country. Institution of the Sangeet Natak Academy has been instrumental in realizing the concept of Ek Bharat Shresth Bharat vision of Government of India. So the Puraskars were given for 2019, 20, 21 in New Delhi. On February 23rd, 2023. So the Academy Fellowship, which is called as the Academy Ratna, carries a prize of 3 lakh rupees, and the Academy Awards, called as the Academy Puraskar, carries a prize of 1 lakh rupees. The award also carries a Tamarapatra and an Angavastram. The awards were given for music, dance, drama, theatre, traditional, tribal and folk music as well. It also includes puppetry, and the contributions of scholars and various contributors in performing arts were also awarded through fellowships. The next most important news, and the last also, is that now post-budget webinars are being conducted by Prime Minister, and the first post-budget webinar with regard to green growth is being conducted. So the Prime Minister addressed the post-budget webinar, which is a series of 12 post-budget webinars, let me tell you, and this is organized by the government with the intention to seek ideas and suggestions for effective implementation of the budget 2023. So the first post-budget webinar is with regard to your green growth, and green growth is one of the 7 top priorities or the Saptarishis in the government budget of 2023, which ushers in a green growth. So green industrial growth and economic transition, which is both environmentally friendly and also sustainable, is being aimed by the government, and it will generate a large number of jobs. Let me tell you, government has taken a large number of steps with regard to green growth and envisaged a number of projects and initiatives which are spread across the country and also across ministries. For example, you have the green hydrogen mission, the green transition energy project, energy storage projects, renewable energy evaluation, the green credit program, PM Pranam Gobardhan scheme, the Bharatiya Prakritik Kheti Bio Input Resource Center, Mishti Amrit Dharohar, coastal shipping and vehicle replacement. And also recently government is going to start the carbon trading scheme as well in the Indian market. So this is about the webinar by the Union Ministry of Power, which will have sessions for getting ideas and for effective implementation with regard to the Saptarishi. So you have 12 webinars coming out. Definitely the inputs will be a very important resource for you to get ideas with regard to your answer writing and also good essays. So I suggest you that you should follow these webinars for sure. So 12 webinars coming, 12 most important topics. And yes, this is it for the week gone by with regard to your polity and governance. I'm sure and I hope that this really helped you. If you did find this helpful, please like, share, subscribe and follow me for your weekly updates and also for your daily updates. And until then, as usual, it's very happy learning. Bye-bye.